November 10th or 12th that he passed away. And so I'm going to call the meeting to order, and pursuant to our agenda, we did want to start by remembering Bob. And I just wanted to say I'm going to be acting chair for this meeting, and then I think we can put it on a subsequent agenda that we will have a vote on chair and vice chair probably at the next meeting. That's because with Bob's vacancy, we expect that position to be filled. And to me, it makes sense to, once we have a full board again, to then have an election for chair and vice chair. So I will be in this role for this meeting, and then we'll see what we do as a group when we have a fully reconstituted board next month. So I thought that it would be nice to just have a moment of silence for Bob, maybe like a minute of silence. And after that, for people to just say a few words if they want to. And I think we have people who will want to say a few words. So I'm actually going to save my words for after the moment of silence. But maybe we would just honor him for a minute and then come back and.
Anne?
Yeah.
Do you think it would be appropriate to make sure we have a quorum and do a roll call first, or
Sure,
do you want to wait to do that?
Let's do the roll call.
Okay,
Sorry about that. Thank you.
Good afternoon, everyone. Professor Ann Fromm, I know you're here. Laura Fitzsimmons. Rob Tellis. Julie Kavanaugh-Bell. I think everybody's on mute.
Yeah, please unmute if to say you're here if you.
Okay,
if I could interrupt, this is Lorinda. Cynthia, if you're the one taking the roll call, it sounds to me like you have a rag in your mouth or your hand over the microphone. I can't understand
yeah,
what you're saying.
my little camera's not working that well.
That was a little better, though.
Oh, okay, I'll put my head up. Joni Eastley. I think she's here. Joni, are you on mute?
I don't see her on this, unless she might be calling in.
Yeah, she's calling in, and I thought she joined, but she might be on mute. Joni, you on mute? I think it's *6.
Can you?
There you are.
Can you hear me now?
Yes, thank you.
Okay, yes, I'm here. Thank you.
Lorinda?
I'm here, but you know that. Thank you.
Dave Mendiola?
Present.
Jeff Wells?
He's having laptop problems. He's working in his office to try to get them resolved. If he can't get it resolved in the next few minutes, he's going to come into my office with me.
Okay. Drew, you're here.
Yep.
Kate Thomas?
I'm here.
Okay. Justice Maupin? Okay, I believe that's all. And let you all know that we're being recorded.
Alrighty. So looks like we have a number of people who are joining us, just non-board members. So we may be hearing from them shortly.
Right. We have 8 present so far, and probably 9. So we have a quorum.
Okay, so that's good. And we'll get to public comments for those of you who have public comments in a moment. So right now I'm going to start with just a moment of reflection, and then we can have people can share a few words about Bob after that. So let's just be silent for a moment. All right. Does anyone want to start? Laura, do you want to start? I think you might be muted.
I wrote this the night that I was told that Bob would not make it through the night. But I wrote it in the past tense. And that kind of started the healing process. Okay. A lot of people knew Bob Kroll better and longer than I did. My heart goes out to them all. My heart also goes out to the communities he served. They may not know what they have lost. They have lost a selfless, consensus-building, and principled advocate. Bob, and we all know this, Bob could sit for hours in rooms with people who righteously argued their positions and talked over one another. Bob would not weigh in. He would listen. He would really listen. And then he would find common ground, and we would all move forward. He was a devoted husband, father, and grandfather. I don't have the words to speak for their loss. I believe I am one voice who can speak about my friend, my neighbor, and my colleague. His service as mayor of Carson City, where he doggedly and graciously led us out of the recession into a community of pride, compassion, and vision. His service to the State Bar of Nevada during very troubled times, always mindful of the potential of our professions to serve well and honorably. His understanding of the unique needs of rural Nevadans, where he has always proudly acknowledged his roots, his humility and his humor. As I think about the stories that Bob would share with me, I realized there was always a lesson tucked away in there. It was never an easy lesson, and it was never forced. But the lesson was there if I was ready to listen. Sometimes I was, and sometimes I wasn't. But he told me anyway, because he had faith in me as he had faith in all of us. I have known people who have been more powerful and widely known than Bob Kroll, but I've known few that have been as heroic. We have lost a great man. There's a hole in our neighborhood, in our town, and in the hearts of all of us that loved him.
That is really nice. Does anyone else want to share any words about Bob? Anyone on the phone, if you're there?
And Dave Mendiola out in Humboldt County. I didn't know Bob terribly well. What I can tell you though is every time I walked into a room with him, he would literally come across the room and seek me out. Part of it was because I knew he loved Winnemucca, and he would say that every time. I love Winnemucca, I love coming there. And then he would ask me about myself, and every time it was something different about my family, about my profession, about my background. And that meant a lot to me, and I know he's done that to everybody. So just truly a great guy, and he actually pulled me aside on several issues and mentored me on them. And boy, they did me a lot of good as I learned the job here in Humboldt County. So my heart goes out to him and his family, and rest in peace.
And Chairwoman Trump, we just wanted everyone to know at the department that we're extremely grateful for the time that we had with Mayor Kroll. He would just call us up randomly to check up on us. He knew that we had a big road ahead of us, and he was just, calling up to make sure we're doing okay, and just made us feel better during most of our really stressful times. So we were just extremely grateful that we had him for the months that we had him on this board. It's so sad that we've lost him, but he taught us so much in that short period of time that we've dealt with him. So we are ever so grateful for him, and we are so sorry for his family for that loss.
That's a really nice thing. I mean, I'll just add that I didn't know him at all. I mean, I literally have been on boards with him for several years, and because we had this goal of meeting in person, which of course then COVID sort of killed that goal, unfortunately. but he's just an incredible role model and such a decent person who just has this mix. He was sort of a mix of slow and fast, which I really always cracked me up a little bit, which is he's so generous with his time and so sort of low key and great at listening. And then he would call on someone and he would say, go. And like there was sort of a New York clip to it that really cracked me up. But part of it is that he was an incredibly decent person and was a role model in the sense that he was spending his time doing this work and really investing a lot of time in it, making time for it. And that just is a reminder of just that it made us feel like the work reminded us that the work is important, right? That we are here for a reason with a job to do, and that he could really see that and kind of see through some of the occasional sort of acrimony or confusion or sort of dissension and just kind of keep it together because he knew it was important and reinforced that to everybody. So that can be something that we carry on this board as we move forward. Anybody else want to say anything? So we'll miss him very dearly, and we can honor him in just being like him and in the work that we get done. I mean, he really was a role model in that way. So I hope we can honor him in that by being decent and kind and generous to each other and realizing that we're all human beings sort of trying to have a positive impact. Okay, so I'm going to go to public comment now. I know that we have people who are here, and we really appreciate that you're taking the time out of your schedule. I'm getting feedback. Is that coming? I don't want to be talking over someone. Am I talking over someone?
I'm getting feedback too.
Okay, so if I'm talking over you, I apologize for that. And I don't know if there's so hopefully I'll hear from you if I do. Anyway, I apologize in advance, but keep piping up.
Chairwoman Strom, I believe it was Kristen Hill is intending to make public comment, but it was causing feedback, so I have muted her until you're done speaking. Okay. And then she can unmute herself. Okay. When the time comes.
Okay, so that'll just be momentarily, Ms. Hill. So we appreciate people showing up for this meeting and joining us. And we have, for this meeting, we're limiting public comment to 3 minutes. So we'll try to honor that as close as we can, just so that we can get to everybody. And I say that we'll also have public comment at the end. So Ms. Hill, why don't you go first? And then for other people, if you're on the video, you could raise your hand and I'll call on you that way if you see the little hand. But otherwise, let's just, I'll just be patient and I'll try to make sure I get to everybody. So go ahead, Ms. Hill.
Thank you. I appreciate the opportunity to speak. I'll keep it brief because I previously wrote you a letter voicing some of my concerns. I would really encourage the board to allow public defender offices to keep their own case management system rather than utilizing a statewide system. Elko County previously was using Justware. We have now entered into a contract with Tyler Technologies. So our office, Justice Court and the district courts will be utilizing that system, hopefully. This will be a real advantage to my office. Our caseworkers will not have to input information that we receive from the courts. That information will be coming directly to our office from the courts. Court dates will be sent directly over to us. Because the courts will also be on the system, as you probably know, they have to report to the AOC monthly. So Tyler Technologies and the courts are used to providing reports. I'm certain that we would be able to provide whatever information it is that DIDS needs from us through working with Tyler Technologies and generating those reports. But again, we're going to have to utilize both systems if we're required to be on the DIDS system, which duplicates the work for my staff that's already really overworked. So again, it would be one thing if we were given the opportunity and couldn't comply, but I'm certain that we can. And so I would really appreciate the opportunity to be able to do that before, we're mandated to join the same case management system.
Thank you very much for
Thank
that.
you very much for that.
Is there another person who would like to make a public comment? Hearing none, I'm going to move on. If somebody joins, I'm not sure I'll see them, but we'll have public comment again at the end of the meeting. So if someone is not here now or wants to say more at the end, we'll come back. Okay, I think the next item on the agenda is the approval of the minutes. We have 2 meeting minutes that were circulated, one from June 17th and another from June 29th. Those were circulated to the board prior to this meeting. So any comments on the meetings, on the minutes?
Madam Chair, it's Joni Eastley. I'll make a motion to approve.
We have a second?
I'll second. This is Ms. Kavanaugh.
Thank you. All in favor of approving the minutes from June 17th and June 29th, 2020?
Aye.
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 Okay, those minutes are approved. Thank you very much. So now the next thing on the agenda is an update on the Davis versus state litigation. Mr. Newby, I think that are you starting us off on that?
I believe so.
Great.
Good afternoon, everyone. Craig Newby, Deputy Solicitor General for the state of Nevada. I'm going to provide a brief update on the Davis matter, in which, and I believe the department has circulated this to you. There is a stipulated consent judgment that's been signed by Judge Wilson in First Judicial District Court as of August 11th. Currently, efforts are being made to provide notice by the agreement of the parties as broadly and as widely as desired by plaintiffs, such that if anyone has concerns about the settlement, they're able to make the appropriate filing with Judge Wilson in the First Judicial District Court. Outside of that, there are some initial deadlines that are within the settlement agreement. Many of those are within the document that's been circulated at least once before we sought to get this approved, and then at other times where there's a within 6 months of effective date. And so we're looking at February, rough justice, February 2021 to comply with those types of deadlines, such as having a standard contract, Ms. Riva approving county contracts, things of that sort. And I see there's a PowerPoint there that people can read much more easily than me reading the PowerPoint to them. So I'm not going to do that. The most important development in the case, which is going to be a transition to me stop talking and address any questions that the board might have, is the parties following consultation with, at least on my part, consulting with the department and consulting with the governor's office, have agreed to a stipulated monitor. Professor Hanan from UNLV Boyd School of Law, who is fantastic and who I believe is going to be participating in this call to introduce herself. We've held the parties to the Davis case have had an initial meeting with her along with the department to make sure she knows of what's involved with the settlement, as well as the resources available for her to monitor the work that this board and this department are going to be doing over the next years to improve rural indigent defense. And with that, I'm happy to take any questions that people have, or otherwise I'll turn it back over to Interim Chair Trom, and then ultimately to her colleague, the new monitor of this case.
Sorry. Thank you. Ms. Fitzsimmons, do you have a comment?
I just have a quick question. Craig, when you said that there's going to be a period of time now for people to object, that's limited to members of the plaintiff's class, is that correct?
That is absolutely correct. With any class action case, to make sure that members of the class are being properly represented, you try to send out as much notice as possible. In the context of consumer type class actions, which most of us as lay people are used to, you get the notice, you get the piece of paper in the mail that says you could get 50 cents from this settlement because someone sold you, Apple sold you something that was too expensive in the App Store, something like that. And you have a right to complain about it if you don't think it's fair, since you're a member of that class. In this situation, where we're dealing with indigent defendants who generally are in the, many of whom are in the criminal justice system, notice is a little trickier and different. And that notice has been provided as requested as plaintiffs to the best of our ability. And we'll see if anyone from that class objects to the settlement to Judge Wilson.
Okay, any other questions?
I just would ask that the minutes reflect that Jeff Wells has joined the meeting.
Hi, Jeff. Okay, any other questions for Mr. Newby? So Professor Hanan, are you with us? I don't know. I thought she was. Let's see. I do not see. Let's see.
Hello.
Hi. Are you, Professor?
Hi. Good.
Are you there?
Yes, I am. I'm here by phone. I wasn't sure if I could join online. I tried, but I think I'm in a waiting room if there is an online through Microsoft Teams. But that's fine. I'm happy to appear by phone. It's just a new interface for me, Microsoft Teams. So hello, everyone. I am Eve Hanan, and as you heard, I have agreed to serve as the monitor for the settlement. I've been involved in public defense since 1999, when I started my career as a public defender in the Boston area, in an office which was also charged with doing CLE trainings and some quality assurance for panel attorneys in Massachusetts. I worked in DC and for a spell in Maryland, where I also did litigation support for attorneys in the public defender offices around Maryland. So I do now teach. I teach with my colleague Ann Traum, and I teach criminal law at UNLV. So that's a very brief introduction to me, but I'm looking forward to working with all of you. And at this point, I'm really just getting up to speed, absorbing and digesting all of the material, and plan to be in touch after that with follow-up questions. So thank you for letting me address the board today.
That's great. Does anyone have any questions for Professor Hanan at this point? I would expect that the sort of first big set of deadlines are those 6-month deadlines, and so that we maybe will be hearing from you around that time and have you back at the board. So thank you very much.
Thank you. I'm not sure how to remute myself, or if that needs to happen on your end.
Ooh.
I guess I could do it on my phone, but I think I can do it on my phone. We'll see here.
*6. It's *6.
*6. Okay. All right. Great. Thank you so much.
Okay. Great. Thank you. Let's go on to number 6 on our agenda. We have a couple of different kinds of updates on here, 6, 7, 8. And from Executive Director Marcy Riva. So Marcy, are you ready to go?
Yes, so I wanted to update the board that we're kind of hitting the final go around of what's going on with our IFC requests. We were able to complete our contract for our weighted caseload study. The contract was finalized with the National Center for State Courts, and I've requested that Suzanne Tallarico, who is the Principal Court Management Consultant for NCSC, do a short presentation of what the next steps will be. And I saw that she's here, so I'd ask if she could maybe pop in and start her presentation for the board, or her discussion.
Great. We see you.
Sure. Thank you very much for having me. We're excited about this project. Before I get started, I do want to say that I have a colleague on this call as well, Brian Ostrom. So Brian, you can either show your face or not. I don't care, but If there's something that you feel like you want to add to what I'm saying, please unmute and interrupt me at any time. So Marcy's asked me to make just quite a brief presentation to the board about what this project will look like, and particularly talk a little bit about advisory committee that that when we do these projects, we always work with. So I'll first talk a little bit about the project in general, and then I'll talk about the purpose of the advisory committee. So first of all, what we're doing is a weighted caseload study. Basically, it is a time and motion study. Kind of looked like from the spreadsheet that Marcy put up that what Mr. Newby is looking at has some overlap or looks similar to what we're going to be doing. Basically, this is for just the rural indigent defense counties. And as I said, well, the primary piece of this will be a time study. We'll work with the advisory committee to help us make a lot of the decisions about this project. And we'll talk again about the advisory committee later on. But basically, just to start with, a time study or a weighted caseload study really is an opportunity for us to be able to say, how much time does it take people serving the indigent defense community, that is attorneys, investigators, and support staff, to process the cases by case type. One of the things that we'll have to do with the advisory committee is identify what those case types are that we want to study, as well as a number of other things. So based on how much time it takes to process those cases, and then comparing those or marrying that with case filing data, we can then say by each county location, how many attorneys, how many staff, and how many investigators you would need to be able to provide the correct complement of staffing to allow them to process those cases in a given year, anticipating certain number of cases. Just a couple of things that it's not. This is not an individual performance review. We do not look at individual data. In fact, the power of this model is that we aggregate the time from all across the state and generate average case processing times or case weights for the state, not just for each individual location. We will have some supporting things that go, well, let me just talk about the time study for a minute. When I spoke with Marcy, she did indicate that you have a relatively low number of attorneys who would be participating in this study. I think it's around 40 or so. That's going to help us, that and the number of cases that they process in a year will help us determine how long we should collect data. Generally, we're collecting time for anywhere between 4 and 6 weeks. So it does require those people who are participating to literally track how much time they're spending on different case types and different activities for that period of time. So again, we'll work that out with the advisory committee. So that's the time study piece, tracking what you do on a daily basis, including the work you're doing outside of traditional working hours, including the time you're spending on weekends and evenings. So we want to get all of the work time that people are engaged in that work. And we also include non-case related work, meetings, supervisory kinds of activities, that sort of thing. So that's the time study. That's going to be supported by 5 different other elements. We've got 2 surveys. We'll also do focus groups, and then we'll complete this process with the Delphi process. I'll talk about each of those independently. So the first survey is in the RFP. One of the things that we were asked to look at is to get basically a set of census data from all of the attorneys that are working in this area. So how long have they been attorneys? Do they supervise people? Do they have access to support staff and or investigators? So we'll put a survey together. We'll run that by Marcy and her staff at DIDS. And that'll be one of the first things that we'll do. We will also be doing focus groups, and given the current status of the pandemic and where we are, Marcy and I talked about probably doing the actual time study data collection in probably February, March time period. Hopefully that gives us time to start to get things back to normal a little bit. So since we're going to wait until that time period, which is several months away, we think that it might make sense to do the focus groups up front. Normally what we do with the focus groups, and we'll still do this, is to get some sense of people about, basically where are the bottlenecks in their work? Where do they struggle to find time to complete their work? Are there steps that they think they should be doing that they rush through or don't do? because they simply don't have time. For example, when we do weighted caseload studies with judges, one of the things that they tell us is that they don't generally have enough time to really sit down and think through their decisions and opinions. And so oftentimes they're going back to old cases and boilerplating that information on new cases. So we're looking for that kind of information from the attorneys, investigators, and support staff. So we want to do focus groups with all of them. The other thing that we're finding right now during this period is that it's really going to be important to basically find out what people are doing now in the pandemic that that they think they're going to probably use in the future, continue to do in the future. So I'm assuming that in Nevada, some court hearings are being done either by Microsoft Teams, through Zoom, or Blue Jeans, or some other kind of software that allows you to carry on your court hearings while not having people in the same place. So one of the things that we're finding when we do focus groups with judges and other people who work in the courts is that they're saying, you know, we think this Zoom thing, while it isn't necessarily the best thing for all case types, it's pretty darn good and handy for certain types of cases or certain types of hearings. So what we want to do is get a sense for where these attorneys and other staff think that some of these changes in their workplace are going to continue on. And then that will help us to actually isolate those things in the data collection in case in the future they don't continue as we think they are. And then that gives us some ability to update the case weights or the workload values. So that's the first survey in the focus groups. We'll also do another survey. This one generally follows up the time study, but it can be done anytime, and that's called an adequacy of time survey. And essentially it's similar to what we get out of focus groups, but it allows us to put a numerical value on, again, by each case type, where people feel like they do or do not have adequate time to process certain cases. This all this information, the data from the focus groups, the data from the adequacy of time survey, and the time study all help us to look at all this time information and determine whether or not we feel it was accurate, and more importantly, is it the way it should be? So when you do a time study, basically you're capturing how much time are people currently spending doing the work they're doing. But what you really want to know is how much time do they really think they should be engaging in these activities to be able to do a thorough and quality product. So we'll first work with Delphi or expert groups, and we have a series of activities that we'll take them through and exercises to basically walk people. So if you're an expert in felony case processing, we'll have an expert group of felonies. We might have an expert group on juvenile case types. We might have an expert group on misdemeanors. That again will work out with the advisory board. But basically we'll go do a deep dive with that information and make sure that those people are comfortable with those case weights that we've generated. Once we do that, we'll bring the information back to our advisory committee, and then we'll finalize all the case weights. And that's when we'll also look at the model that shows basically what kind of a need we have. So that brings me to the advisory committee then. Marcy and I have already spoken a little bit about this and talked about what the makeup should be. But essentially, the advisory committee really is our decision-making group. We like to say that we bring the expertise in conducting weighted caseload studies to a particular state or location, but we rely on that state or location to be the experts in the work that you all do. So I'm sure you all are aware that, you know, the way people process cases from state to state is different. The language that you use from state to state is different. And so that's one of the things we will rely on our advisory committee to do, is to help us to understand how the system works in Nevada. The other thing is that, as I mentioned earlier, we'll have to, at our initial meeting, identify what are the case types that we want to measure, what are the activities that we want to measure. And that's activities not only for the attorneys, but activities for the support staff and the investigators as well. So we'll need representatives from each of those three groups. So you need people who actually are doing the work day in and day out to be able to provide us with that information about what we can measure and what we should measure. So once we have, and then there are other details about setting up the study that we'll work with them as well. One of the things that we have to do is decide what's the average amount of time we think an attorney should work, and we have some examples of that we'll bring. And just a couple of other things. When do we want to, what are the actual dates we want to conduct the study, et cetera, et cetera. One other important thing that we may need to explore in Nevada, and Marcy and I touched on this when we first spoke, is that there may need to be some marketing component to this project. It's my understanding that DIDS does not necessarily have any kind of authority over the attorneys that would be participating in this study to say that you must participate in the study. However, if you want to be adequately staffed and you want it to be representative of all indigent defense providers, we really need everybody to participate. If we only had 20 or half of the staff participating, we might not get adequate data, and it could just be a waste of time for everybody. So we're really going to have to think through that marketing piece and how we get people on board with participating, but participating with a full-on effort. So that's going to be a big part of this. Generally, we meet with the advisory committee 3 times. So we'll have an initial meeting where we lay out all the details of the entire project, including the time study, the surveys, focus groups, and Delphi groups. Then what we'll do is, as I said, we'll start with the focus groups. We'll run the time study in between. We also have to do some training, and we'll talk a little bit about that. But midway, we'll meet with the advisory committee again to basically provide them with the draft information. So we'll give them those draft case weights. We'll give them the outcomes of the focus group information and the survey information so that they have a sense of what it is we're going to talk to the Delphi groups about, and they're informed before we move on to the work with the Delphi groups. We'd then work with the Delphi groups. They would make recommendations for any kind of adjustments on those case weights, if any. And then we would come back to the final advisory committee, show them all of the material and the recommendations of the Delphi groups, and finalize all the case weights. This entire process will take about 10 months, I think is what we put in the proposal. Once we have all of that developed, we will write a report that'll basically outline everything we did, including all of the meetings, all of the decisions that were made, and most importantly, what the case weights are, and we'll also provide you with an Excel spreadsheet that is a model that can be used to update your needs for years to come. Generally, what we say are these workload values are good for somewhere between 5 to 7 years. I'll tell you a little secret, and that is that most states come back to us about every 10 years. And the reason that we say that updates should be made is that inevitably there are law changes, there are process changes, like your first guest who wanted to make a comment said, there are changes in case management systems, all of which change the way people process their cases. So that's the reason that we recommend updates from time to time. And just by way of a little bit of information about me, I have worked in Nevada once. I did work in Washoe County to do a weighted caseload study there. It's been quite some time now, maybe 13, 14 years ago. But I did work there, and those judges did do it, and I was not involved, but our organization has also done a weighted caseload study with judges in Clark County in the past. So you do have some experience in your state, at least, of using this model and this methodology through the center. So I'm happy to take questions if anyone has any.
Go ahead, Laura.
Francesco Realtor. Whoops, sorry. Francesco Realtor. Are the survey responses anonymous? I mean, you know who they are, but if I'm responding to one of your surveys, my responses won't go beyond you?
Yes, that is correct. So for the first survey, that census survey, we will obviously have to put your names on those. But again, that won't be shared. All of the other data basically does not have a name attached. So even in the time study, we have a user ID so that we know who you are, and that's only for us to know like what county somebody's from and if we need to make any adjustments, but it's never looked at individually and it is not shared. So aside from that census data, your name will never even be associated with any of the data that we're collecting.
And I have a couple of questions if I can.
Go ahead.
And half of this question may be to Marcy, because I was worried about your very opening comment, which was you only have 40 attorneys that you're working on. Marcy, was this contract only a rural-based contract, or does it include Clark and Washoe?
This was for a rural caseload or rural study, so it does not include Washoe.
Okay, and that's fine, because I had long recognized, I think we all have, that a caseload number for Washoe and Clark will be remarkably different than it will be for the rural things. As another aside, we have used, my staff and I have used your court caseload studies and how long it takes a judge to do so much for this and so much for that. I've used those regularly, even stealing from some of your more recent California ones and other states, and I have my staff merge them together and stuff like that and cheat that way and call them our studies. But I'm wondering if at the end of the day, you're going to try to come up with a raw number that each lawyer can only handle X number of cases, or if you're going to do it more like you had done with some of your judicial studies, where you come in and you say an average felony takes X number of minutes and an average civil case takes so many minutes. I'm curious which way you intend to go.
The latter. And the reason
Good.
for that
That's what I was hoping for.
And the reason for that is that we don't know what a makeup of a caseload would be. If an attorney has, I don't know, can they handle 200 misdemeanors in a year, but only 100 felonies? And then if one of well, I guess we're not going to do death penalty cases, but so it really depends on the makeup of the case, which is why you want to assign just those workload or those case weights just to the case type.
No, I appreciate that. And like I said, I've used that data that you have done for judicial departments already, and we use it regularly. So that's good.
Great.
That was all my questions, Ann. Thank you.
I have a question, but I don't think the question is for you, which is, maybe we'll see it over time and if there's not an answer today, but I'm curious about how our case weighting intersects with what's required for workload study in the settlement. Are they the same? Is this our way of implementing that as well and meeting that obligation? Yes. Okay. You want to say anything about that, Marcy or Craig?
That was our intention in this study, is to create that Delphi study that is required under Davis, and that's what they will be doing, is a Delphi study.
Okay, that's good. Anyone else? So you've proposed. First of all, thank you very much for all that information, and you've outlined what I think is going to be an action item, if I'm correct about that, about just moving forward with the creation of this advisory committee for the weighted caseload study. So do we want to do that now?
That's correct, Chairwoman. I am requesting authority from the board to form this advisory committee. I have up on the screen what I think would be a good setup of this advisory committee, and I have shared this information with Ms. Tallarico, and she did think that this was a good setup. You know, we will be acting as a liaison with NCSC to give them any information that they need. The data analyst that I'll talk about in the next item will also be working with the advisory committee to provide them information. But they did recommend that we need to form an advisory committee of up to 15 members. So basically what we're recommending at this point is 9 attorneys. We think 1 should be from the state public defender, 4 county public defenders, so 1 from each Elko, Churchill, Humboldt, and Pershing. And Churchill hasn't started their public defender's office, but it will be in place, and we've already reached out to the public defender there. 4 contract attorneys, and we're thinking we have had interest from White Pine, and we would like to reach out likely to Douglas, Lyon, and Nye. But these are flexible depending on interest, to try and get a total of 4 contract attorneys. We also would like to get support staff, 1 from the state public defender and 2 from county public defenders offices. So we're thinking Elko and Humboldt, since they're more established. And there's only 1 office that has investigators. So it'd be 1 investigator from the state public defender's office, and then would be requesting 2 board members be on as well.
Okay. So does anyone have questions about this, the committee or the makeup of the committee that's been proposed by Ms. Reba?
So I at least have a question. While I recognize county administration are not necessarily experts in how public defense is done, they are certainly experts in the budget side. I think you should have one or two of them from the rural counties on this advisory group so that they will understand what went into it better and would be able to explain it to their counterparts after it's done, as opposed to having everybody going into cardiac arrest when they see what the recommendation is going to be.
And Ms. Talarico, I don't know if you're still there, if you have a response to that.
I am still here. You know, I think that would be fine, and I think you make a good point that not only do you have to do the marketing up front, but you have to do the selling of it on the back end. So what my recommendation would be is that you could have a couple of people like that in the meetings, but I would still not want to give up the people who are actually doing the work. So I would make them additive instead of.
That was, my suggestion really was to make them additive.
Okay, yeah, I think that would be fine.
I guess my question on that, Jeff, is whether we have board experts, like whether our board members on the committee might supply some of that expertise, at least. But it may be that they're, I mean, I'm not sure if they'd be coming from the counties.
Well, Dave or Joni or myself, you certainly got several people, and I'm forgetting somebody I know, but you have several people who have that expertise.
Okay, any other comments or questions about the proposal to put together this advisory committee on the case weight study?
Chair Trump,
Yeah,
Dave Mendiola.
Yes.
Just would agree with Jeff that I don't think, in my case, I know that I would probably be of no value in terms of the details and the semantics, but I would appreciate participating so that I can raise my level of knowledge for sure. And then on the backside, I could certainly help sell it.
Ooh, that's a great point. That's a great point, Dave.
Laura, we can't hear you. Go ahead.
Chairwoman Trom, Dag Sophia Long is not here. I don't know if you want Ashish from the Attorney General's office to chime in as to how many board members we could have without requiring having open meeting law kick in. So we have 13 members.
We have 13 members on our board. We've proposed having 1 to 2 board members on this advisory committee. So is Ashish there? I don't know if I can see him. Do you?
There?
Is he?
Madam Chair?
Yes?
It's Joni Eastley in Tonopah. I am confused on the OML in this regard. I think it doesn't matter how many people are on the advisory committee. If they are appointed by the chair, then I think the open meeting law applies.
Oh, okay.
I believe so, but I've been out of office for several years, and there have been a number of changes to the open meeting law, so I'm not entirely sure.
Okay, so you're...
Hi, Madam Chair.
Yes.
This is Ashish. Can you hear me?
Yes, we can.
Sorry, I
Thank
think
you
I
very
was on.
much. Go ahead.
Perfect. Sorry, I think I was on mute, so I was trying to unmute myself. The open meeting law applies whenever we have 2 or more board members meeting to either deliberate or take action on any item that's a matter of board business. So if you created a subcommittee and there were even 2 people on there doing deliberation, then that would have to be that would also be subject to the open meeting law.
Okay, we have 2 proposed, 1 to 2 right now. I guess there's sort of several questions, and I see I have a hand up. Is that you, Suzanne?
Yes, it is.
Yeah, go ahead, please.
I just wanted to be clear that one of the things that I recommended to Marcy was that the two board members that would serve on the committee would be non-voting. So I don't know if that makes a difference because they wouldn't be making decisions, but they would be there basically so that they understand what's going on with the study and not making decisions on it.
Okay, Ashish, does that make a difference?
Yeah, I mean, that's an interesting question. Essentially, what you're saying is that they would not be deliberating in any way. Is that correct?
Yeah.
They'd be bringing back something to the board for the full board to make the decision.
No, I believe that this is Marcy, Reba, what Ms. Tallarico said is that the advisory group would make the decisions as to how this study would go forward. It would not be brought back to the board again until the completion of the study. Is that correct?
That's correct, yes.
So the board members, I guess the board members are there sort of just as non-voting participants. But if that's the case, it seems like they would be able to lend their expertise. And I just am wondering about the sort of deliberative aspect of that.
Yeah, Ashish here for the record. I think, you know, they can be there, but if there is deliberation amongst the board members regarding these items that would be of board business, then I think that would be problematic. So you'd probably just want to have them there to observe, and then upon the study being presented back to the full board, then at that time, those members would be able to provide any summary of observations they had for deliberation and action in front of the full board.
Jeff?
Anne, can I ask a question?
Of course, go ahead.
So my observation would be that the advisory committee is not a subcommittee of this board. It's a committee that's being appointed by our vendor. I doubt our contract requires our vendor to have a committee. I think our vendor can create whatever kind of committee they want to assist them in this and participate, and I don't think they're subject to the open meetings law at all. Because it is the contract vendor who is choosing who they want to have advise them.
That's a great point.
I have a question for Ashish. So is it a problem when, for any of two of us to be deliberating about things that we're eventually going to be voting on?
Yes, I mean, that is the essential issue, and that's why it's not dispositive, or actually it doesn't change the analysis that an outside contractor would be choosing the two members, because the OML applies to the members at the time that they are appointed to the board or commission. So it's not relevant and sort of dispositive that the outside contractor would maybe choosing the two members, but the simple fact that you have two or more members who would be deliberating about board business beforehand would be what subjects that committee to the open meeting law, because it would be a subcommittee acting further. I apologize if I'm missing something, but I see it as you know, the OML applies to public body members, and so I wouldn't see that as being sort of an applicable loophole.
So maybe it would seem to me, and I'm happy to hear from people on this, but it would seem to me like it would be hard for this committee to do their work if they had to comply with the open meeting law. Do people agree with? I mean, I assume Suzanne, you would take that view?
Yes, I would agree.
Okay, so it seems like one solution would be to just have one board member on the advisory committee, right? Because that way we don't have an open meeting law problem. And then we've also, okay, and then we've also identified the desire, like the utility of having maybe someone who's not expressly listed on this as being someone with this county level budgeting expertise.
Well, I thought I heard Dave Mineola basically volunteer. No, I mean, Dave, correct me if I'm wrong, but you would be perfect. And,
Right.
you know, if we have one board member, you know, were you volunteering?
Didn't you just get a phone call?
That's what I just heard. I heard him volunteer.
No, I'm happy to volunteer. I was also going to suggest there's a couple other county managers that might even be better if you want that perspective, that actually have a lot of experience in the criminal side of things. And I'd be happy to check with those folks, and that might get us away from having the board member represent that particular group. But I would do that if nobody else was available. So. Thanks, Laura.
So, well, thank you. Thank you for agreeing to be volunteered by the board. So I guess to me, the only question with that approach, Dave, is that can we get those people to participate without having a vote? Do we need to have them on the slate of people that we're recommending, or is that something, as long as there's only one board member and we've approved, is there some flexibility about the number of people that are participating? Does anyone have thoughts on that? Yeah.
My thought on that was, I thought Marcy was going to put this committee together and it's not even coming back to us.
Yeah.
So, Marcy, am I right?
I would like permission to put the committee together. I would like input as to the board member that would like to be on it. But I would like permission to put it together so I can reach out and see who's interested in being on it. And that's our general idea, but we haven't really reached out to everyone because we didn't have permission to form it yet.
And can I make a motion?
Yeah, go ahead.
I move that we authorize Marcy and her staff to form this advisory committee. And I move that Dave Mineola be the board member that sits on the committee. And if Dave is to reach out, like to the Carson City manager or whomever, he can then forward the results of that conversation to Marcy. Does that make sense?
Yeah, my only question on that, just a comment, is, are we limiting Marcy to 15 members? Do we want to put any flexibility in the number of members? Do we want the people that Dave reaches out to augment the size of the committee?
Marcy, what do you think?
I think that, like Ms. Tallarico said, these financial members could be non-voting members as to where we go, but they could be brought in for the marketing as well as the understanding of the extra costs that could come out of this. So I think it would be nice to have them there as non-voting members.
I think that's a good idea. And it also might be that there's other people whose expertise you want to bring in at various points, who could also be non-voting members, but are going to be important to getting the work done and also delivering the messages later.
So do we feel comfortable with that clarification in making the decision Marcy needs to proceed?
Anyone have comments on the motion as put forward?
Madam Chair?
Go ahead.
Julie. Okay, yeah. Thank you. I would also encourage us to look at, even if it's an additional, but one of the members of the judiciary, because I know some of the judges have been very, very interested in what we're putting together. So I think they'd appreciate that opportunity. And I mean, if we're going to go with one board member, I'm fine with Dave too, but I was going to say I would be willing to volunteer as well if that's helpful as a rural attorney. But if we can't have two, then I understand that.
So I think that, I mean, I guess we can hear people's comments. I mean, one question is who is on the committee? And I don't, especially if there's, I don't necessarily view that as a limitation on who the committee can consult and talk to in the process. But other people want to have comments on that?
Well, my comment would be that if you really look, first of all, I think we would need to ask the consultant why she did not put judges on. I can think of a lot of good reasons. I think they need, obviously, any input that they want to give to the advisory committee would be welcome and considered. But, you know, there is an underlying conflict. You know, I recognize when we're talking about county managers and the fiscal impact of this, but that's also something, you know, we're really not supposed to be looking at under the, you know, under the law or under our settlement agreement. But, you know, if we get judges on this, my understanding generally is there's a very real difference of opinion among some of the rural judges. They're all individuals. And I think putting a judge or two on this would unduly weight perhaps one or two, you know, one perspective. I just think it's going to be a lot more efficient if the categories are those as proposed by the consultant who we're entrusting to, you know, undertake this work and who has the experience in this area.
This is Chris. I'm so sorry. I was stuck on mute for quite a while.
Sorry.
Did you vote? That's okay. Did you all vote then on Laura's motion?
We have not voted, and you're welcome to comment. We're just still discussing.
Okay.
Is there a second?
Yes, you need that.
Okay, thank you.
So my guess, it's not to rehash anything, but I've been trying to listen. I apologize. We've had bad weather on the mountain, so it comes and goes. But I do think the committee, you don't want it overly large. It's tied to the contract. You can have an ex officio from the board that just sits in and listens and brings it back, so they're not deliberating. But I do think the AG is actually over interpreting the open OPL. I don't believe there was ever a thing of one or two of you. You could have an entire board or commission getting information as long as you're not deliberating. So I guess I kind of was surprised to hear that only if one or two were put on. That's not in the OML that I know of.
And this is Drew.
Go ahead, Drew.
I have a question too, maybe of the AG, but whether any of us are part of the advisory council, are we allowed to provide advice to this committee? I know both Jeff and I down here in Clark County have been through several case-weighted studies. So we have experience in kind of what we do daily as far as tracking time, but at the same time, actually work with some of these outside organizations. And so I think there would be value whether we're on the advisory committee or not. And to Chris's point, you know, if it is an open meeting law violation, what about if we're not part of the advisory committee, but could lend some advice or answer questions if that committee has some?
I don't know the answer to that question, and maybe there's some disagreement, but Ashish, do you want to respond?
Sure.
Because we have been told different things. Obviously, we're getting mixed messages from experience. Yeah, go ahead.
Yeah, I just want to clarify, you know, the line that I'm speaking about regarding appointment to the advisory committee is specifically about members appointed who would be engaging in deliberation or action. You know, if the intent of this body is to appoint members to simply listen and sort of take information, you know, that does walk the line, but that is not something that I would see or advise is prohibited by the OML. But I would advise that the board should be careful and cognizant of such appointments. The reason that we, you know, generally caution against these types of appointments, especially when you have two or more members, is because it becomes difficult to not deliberate or participate if members are appointed as such. There is no problem with the advisory committee or board that is created without members coming back to this body and requesting information as part of you know, noticed open meetings, because all of the meetings of this body are subject to the OML. So yeah, I don't see conflict there, but I apologize for any miscommunication or lack of clarity on my part. So please let me know if there are any additional questions.
Madam Chair, this is Chris again. So I guess what I don't understand, this advisory committee or whatever it's called is something that's required by the contract, and the contractor will be establishing it. And the issue is whether or not there should be board members or member sitting in, deliberating, not deliberating, whatever. But when you look at the open meeting law on the AG's website, it only pertains to meetings of public bodies. And a public body is any administrative, advisory, executive, or legislative body that expends or disperses or is supported in whole or in part by tax revenue, or which advises and makes recommendation to any entity on expenditures and disbursements. This advisory could fall under that. I'm not clear now what it is we want them to do and why we think it is a public body.
Laura, go ahead.
Yeah, I just, I think all of these points are really interesting. And, the open meeting law stuff, I get it. But if we basically as a group, I'm looking at the time in the agenda, I know this is really important, but we have ultimate confidence in the DIDS staff. We have a consultant we have confidence in. I'm sure Drew knows more about this experience than anybody else. And if he's not on the advisory committee, he's going to be a resource that's available to them. So wouldn't it just simplify it if we put my old new pal Dave, I better not drive through Winnemucca, I guess, after this. But if we put him on from the board and then just let Marcy and her staff do her work, we don't have to renew this discussion every time somebody comes off or whatever. But Chris, and I mean everybody that's spoken, including our DAG to the open meeting law, I think that all of your comments are valuable, but I just don't know that we need to deliberate on this. We don't have a judge, we can deliberate on it, but if we just kind of move forward with Dave from the board and Marcy doing the rest of the appointments, I think it might be progress.
I would agree.
I second that motion Laura just made.
Do we want to vote on the motion as proposed and seconded? Everyone?
You have to dispense of the first motion. They could withdraw it.
Oh.
Madam Chair, did we make a decision on whether the judiciary is going to be included on this committee?
I don't know that there was a motion on that, but so I don't think we've entertained a motion. I think what we have in front of us is a motion brought by Laura Fitzsimmons to act on this request to form an advisory committee on the weighted caseload study as proposed with these members on it, which, as we've discussed, is 15 members, including one board member.
Wow, that's a big committee.
Yeah, and if you're now making an advisory committee to this board, then it is completely subject to the OML. So it just depends on what you want this board to do. If you want the contractor just to establish a work group that Dave would serve on, just so that he gives us feedback as a board, then I think we're done with it, and you don't have to take a motion. You just give direction. But if you really want it to be an advisory committee of this board, then that's a whole different animal.
Chairwoman Traum, reaching out to them, they do not want an advisory committee to the board. They want an advisory committee to the vendor to tell them how they should keep time and how they do it in Nevada. So we're going to give them names of people we think are appropriate, and the vendor will be the ones that are putting the meetings together, and they will not be coming back to this board to give any advice. It's just to set up the weighted caseload study.
So we're just giving them, we're just giving them technical advice.
Right.
So one question,
and Marcy, I think 15 is way too many. That's too large. In my opinion.
I agree.
The number of up to 15 was recommended by the NCSC because they want to have representation of attorneys, support staff, and investigators.
You can do that with 7. You don't need 15.
Well, since they're not being paid and our consultant that we've just heard from that we've hired says this is the standard that we should be doing, I mean, we can all have an opinion. Maybe I think it should be 200, but at a certain point going forward, you know, if we're going to meet these timelines and if we're going to have faith in the hiring decisions we've made, I mean, I'm just going to defer to the person who's done this before. Unless it's going to, you know, these people are serving without pay, and I'm pretty sure the consultant can figure out how to use them the best.
Chair Trump.
Yes, go ahead.
Dave Mendiola. Yeah, I agree with Laura. These guys are the experts in this. They do it all the time. If they say 15 is good, I think we go with it. I don't know why you'd want to go against that recommendation if they're driving the ship. So.
And it may just be 15 people who they would be consulting with one person at a time.
Right. So in whatever format seems
yeah.
best for them. Right. So I think the way that this is in front of us now, just so that we can, I think we're there's a consensus about that we want to move forward with this. I think that the reason the executive director comes to us with this request is just to get a green light to say, I'm moving forward and working with the vendor, and this is how we're going to do it. I don't think we're actually appointing an advisory committee. I think we're just giving the green light to say carry on with the vendor in getting the work done. So I think that if we could have a motion on that, or we could not have a motion on that. I
think that's what my motion said.
Yes.
Because I understood what Marcy said. She was just waiting for us to give her the green light. So I'd like to give her the green light and just acknowledge or whatever, because it's ultimately Marcy's decision, that we have Dave Mendiola available from our board.
Yes.
Madam Chair, call for the vote.
And I still second that motion.
Okay, let's have a vote on that. Everyone in favor of the motion that Laura has made and which Jeff Wells seconded.
Aye.
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 Anyone opposed? Okay, the motion is carried. We'll look forward to the work of these people helping on the case-weighted study. Okay, I think our next item, if I'm following the agenda, is just an update on the data analyst and legal server. Is that right?
That's correct, Madam Chair. So again, going back to that IFC request at the beginning, we had a couple of things, and this is just finalizing some of those. We were allotted funds to employ a data analyst. We finalized a contract with Dr. Mitchell and Harrion, who is with Sobel Solutions. He's been employed to do 7 things. He has to prepare the financial reporting form for the counties. He will be assisting with data collection for the weighted caseload study. So we've advised him that we are doing the weighted caseload study, and he will be assisting in getting information that's needed. He will analyze the county maximum contribution pursuant to the formula once it's adopted by this board. He will prepare a client survey, which is required pursuant to the Davis settlement. He will conduct a fiscal note analysis of any bill draft requests that affect indigent defense and could increase costs related to indigent defense. He will do a wage salary survey looking at prosecution versus defense attorney pay to ensure that there's some sort of parity. That is a recommendation in some of the proposed standards at this point in time. And he also is going to be weighing in on proposing efficient means for appearance in court. Like was addressed by Ms. Tallarico, several individuals or several courts are appearing via Zoom or other means, but some are not, and there's still issues with that. So would like to be able to provide possible efficient means to be able to meet those requirements that are set forth in Davis. And that's mainly the appearance by an attorney at those in custody arraignments or first appearances. So that contract is complete. And then going to our next contract, we've also finalized the contract with Legal Server. These are some important deadlines. Phase 1 is going to be the project initiation phase. This is going to be the kickoff of Legal Server. Phase 2 will be the initial discovery phase, and that'll happen around October 19th. And phase 3 will be the individualized project plan execution phase, which will happen on November 23rd. This software is scheduled to go live around March 16th, and the review and feedback phase will start March 30th. So Legal Server, their contract is set to be completed by May 1st. Everything should be in line by that time. And again, you know, I'm coming to the board to just kind of ask for the green light to continue moving forward with Legal Server. As I said, we have our software kickoff coming up on October 2nd. We have our lead project manager, who's John Williams. He's provided to us by the state of Nevada from EATS, and he is on this call if there are any questions for him. And he'll be really assisting us in putting this together and making sure that Legal Server complies with what our contract is. But in addition to John Williams, they have requested that we provide 1 to 3 individuals who would become site administrators. They would build reports and they'd understand intake needs. And what we're proposing for this is actually the department filling in this. So we would be working with John Williams to set up the entire software. And this means that when the software becomes live, we would all be experts in the software and be able to go out to the counties to train them in how to use the software. And that's why we would like to do it. We are not adding any other players. Basically, we've been told too many cooks in the kitchen makes it a little too hard when it comes to software. So they are requesting that we limit it to John Williams from EATS as well as our department.
Okay, so this is something that you want, this is an action item, right, of just greenlighting this proposal on working with this Legal Server, with this onboarding team?
Yes, we just wanted to make the board aware of what we're doing and make sure we have the green light to go forward with this kickoff and continue proceeding as we are.
Okay, any questions on, comments on this?
No.
Does anyone want to propose the, just agreeing to this request?
I'll move we follow staff's recommendation.
I'll second that motion.
Any comments? Should we ready to take a vote on this? Okay, everyone in favor of the motion?
Aye.
Aye. Aye.
Anyone opposed to the motion? Okay, hearing none, that's approved. Okay, so I think the next thing on the agenda is continuation of discussion on the data collection. I think we talked about this in the spring, and it was Mayor Kroll's wish that we sort of table our discussions and pause and then put it back on the agenda. So Marcy, is that sort of your recollection? And sort of what are we? I don't think this is up for action item. So what are we doing on this? How should we move forward on the data collection issue?
Madam Chair, it is correct. Chairman Crow at the time had requested that this be put on the next meeting. My recollection was when we couldn't come to an agreement on whether or not to require this Legal Server software, that he asked for other individuals to make proposals as to language that should be used in lieu of the language that was proposed by this department. And as we recall, this department is proposing 2 alternate options. Number 1, straight across the board, requiring that everyone use it so that we can provide uniform timekeeping and uniform record keeping as is specifically set out in the statute, or in the alternative, allowing individuals to have a choice, but the cost of whatever software system would not be something that would be supplemented by the state in our maximum contribution formula. We were unable to make an agreement, and this conversation was continued to today to see if anyone wrote in to provide any alternate language, and we have not received anything from the department. What our request is that in speaking with Legal Server, they will have a pretty good showing of what our software system is going to look like by our November 22nd meeting. So I would like to reestablish this discussion in November with a presentation by Legal Server so that the board members can see exactly what happens with Legal Server, and so it can be discussed at that time.
Okay, so that will be sort of a show and tell in November, which might give everyone just a sort of more educated perspective on sort of what it is that Legal Server does, and how that, you know, how it should roll out, because that's sort of the policy question that we're going to circle back to. So I think there's nothing for us to do today. Does anyone have comments, questions on that issue? Is there
I thought Drew was raising his hand.
I can't actually see Drew very well, so go ahead. Do you have a comment, Drew?
Well, no comment, but we've had the privilege of having a legal server presentation down here to the defense members, both the public defender, myself, and the special public defender. So I think a show and tell would be beneficial for the board before they make a global decision as to the state. So.
Okay, yeah, I agree. I mean, I think just having we did go round and round on this a little bit, but I think having an understanding of the process of data collection, just so that we all get it and understand how important it is, and then sort of, and also can flag the issues, because I would expect, I mean, we heard from Ms. Hill this morning, we might hear more about sort of that perspective, and just so that we actually understand what the issues are factually might be really useful. So anyone else have comments on this? Okay, so I think that sounds good to hear more in November when we'll get a fuller picture, and I think that'll help us all. Okay, so the next thing on the agenda is update on the regulations from LCB. Marcy, maybe you could just give us a little, refresh us about what the history is on the regulations and where they are right now.
So just as a little bit of a history on the regulations, we did discuss them January 29th, February 28th, June 17th, June 29th. We've also sent a letter to the judges on March 4th, letting them know of these regulations and providing them with a copy. They were posted on our website on the regulations page under meetings and agendas, and we've also reposted them because we've had renewed interest in seeing our regulations that are proposed. We had originally scheduled that workshop back in March 26th, but we had to cancel it on March 23rd because of COVID. And the regulations were sent off after consulting with Chairman Kroll on March 31st. And the reason is that you are not required to have a workshop prior to sending items to LCB. It's allowed to send them to LCB and have the workshop after. But the reason that we sent them off to LCB is, you know, we didn't know how long the pandemic would be. And since the handbook says that they should be back in 30 days, we thought we'd be in a better place and would have received them by now. We did submit an amended version on June 17th. And in reaching out through our DIG, we anticipated that we'd receive them back by September 1st. We still have not received our regulations back. In discussing with our DIG, some of her prior boards or some of her other boards are receiving their regulations. So we expect that they should be coming soon, but we still have not received them. So once we do receive them, we would have to set a workshop with 15 days notice. Our DAG has informed us we do not need board's input to set the workshop, that the department can set the workshop so that we can move forward. And then we'd need to give 30 days notice for a public hearing. So that's the route that we are still on, but we still have not received our proposed regulations back from LCB.
Okay, so they could come back. It seems like they could come back, in which case then you do the workshop based on maybe the draft that you get back. That would be the subject of the workshop. But if there's much of if there's an additional weight, is there any way that you would just move forward with workshopping it over the fall, or what is your thinking on that?
Well, it's, you know, we could get guidance from the board. If we go forward with what we received back from LCB, we did turn it into them, so it would become a permanent regulation if, you know, whatever was returned back to us is adopted by this board. If we start to do a workshop based on new language or something that hasn't gone to LCB, we would have to send it to LCB and everything would be a temporary regulation. So that's what we were kind of holding out to try and get these back. We hope they're going to be here soon. We've been told they're going to be here soon. And that's what we're just hoping, is that we can hold on a little bit longer and make these a permanent regulation so long as we're agreeable to what comes back.
Okay, so I don't know that there's anything for us to do, but I just want to hear if anyone has a comment on this, and then.
Well, my comment would be I would rather wait till we get it back from LCB because we've heard a lot of conversation from rural judges. I'd like to have them have the ability to see exactly what it says from LCB so that we can then hear from them and make a knowledgeable decision.
Okay.
Madam Chair, this is Joni Eastley. I just have a question. What's taking LCB so long?
I'll let Marcy answer. I think it's the special session, just put them behind, or special sessions, put them behind.
I forgot about that. That makes sense.
So yeah, so I think, I mean, that's what Marcy was saying, that the boards are getting stuff back now, much later than expected, but it is kind of trickling in, and that's why we kind of expect to get it back soon. I mean, I suppose one way to deal with this is just let's wait to get it back from LCB. If it starts to be towards our October meeting, we'll know that like we haven't gotten it back. We can always take additional action if we feel like we're stuck for some reason, but it seems like we'll hear from them.
Thank you.
Okay. So, all right. So I think we're good on that, and we can go on to number 9. This does have an action item. I think we're good on timing for the. So this is about training. Oh, I see. We're having a changing of the guard on training. Do you want us to give us your update, Jared?
Good afternoon, Jared Hickman for the record. Good afternoon, everyone. Hope everyone's doing well. Brief training update. Let me get the PowerPoint up. So this is divided into 2 sections. Just an update as to what the department's been doing with respect to training every month, and then the action item is at the end with respect to a conference in 2021. So briefly, in terms of the monthly CLE update, the slide kind of presents what our goal, target, and methodology is in providing. The goal is at least 1 CLE opportunity per month. Currently, our target is the primary level rural practitioners. The reason for that is more of a build-up issue than anything else. But as we get to the conference level, I think the board will see there's a funding issue there too. But as we work through, our delivery method, especially with the virtual delivery of CLE, we thought it best to keep the group small at least through this year. And then when we get to next year and have got some experience with the delivery, the virtual setup, we can start opening that up to a broader audience. Essentially what we're doing right now is when we get a CLE approved through the CLE board, I send out an initial email blast to those primary level rural practitioners. On our training tab on our website, we post the advertisement there. And then as we get a little bit closer, usually about a week out from the CLE date, I send a reminder to anyone from that group that is not registered for the CLE to remind them that we've got a CLE offering come up. Completed CLEs, I'm not going to spend a whole lot of time here because the flyers for those CLEs were provided to the board in the materials. I think it's worth pointing out that our attendees are right around the 20 mark on average. So we're getting about half that primary level rural practitioner group at this point. Our topics have been good, and we've gotten some positive feedback, as I'll get into here momentarily. I think demonstrating the need for a build up and starting with a slower audience is our very first CLE. We did it in conjunction with the Washoe County Public Defender's Office and the 2 offices down in Clark County, the Clark County Public Defender and Special Public Defender. It was done through Zoom. We had some technical issues. The participant limitation was only 100. So we had on, I guess, what I'd call the rural side, we had a couple of people that had rearranged some schedules to attend, and then they ultimately were not able to. So as we work through the team's presentations, I think it's good to have the smaller group so we get a better feel of our limitations and how the system operates. This slide is the August and September This slide is the August and September completed CLE. Again, you've got the handout, so I'm not going to spend a whole lot of time there. Our October, November, and December offerings are still to be announced. I will note that October, we've got a CLE, pending the planning session. One of our potential presenters is on vacation, and I think we'll get that hashed out at the end of the month when he returns. November CLE has been approved for November 6th. It's with Attorney Christine I always say this wrong. Kuzemka. Thank you. From the State Bar, and she's going to be doing a presentation on wellness, and that'll qualify for a substance abuse CLE. And then December, we've got some ideas floating around, but that is still very much in the formation stage. So once we get some better definition to that, we will get that posted as well. But the November CLE should be up on the website by the end of this week. Our feedback loop is important because it lets us know, how we're doing with our presentations and our classes, and also, where to direct future CLEs. On this slide, I've got a copy of our evaluation form, and then kind of the data that we've gotten back so far. As you can see in the first section, we're trying to ensure that our learning objectives are defined, that they're engaging. The attorneys are actually involved in the CLE. They actually present useful strategies for real world issues, and that we are providing quality faculty. You can see we're above. The scale is 1 to 5, 1 being the worst, 5 being the best. You can see we're above 4 on all of them, and I've got all of them asterisks. And the reason for that is one of the evaluations we got back, I believe for the Strickland CLE, scored everything as a 1, but under the question 2, the comments and suggestions, the response was excellent presentation with good discussion. So I don't know if it was just a not reading the form clearly or what happened there, but I think that those numbers may actually be a little bit higher than they are. The last 2 pieces of our feedback loop, regard subjective comments regarding subject matter, the instructors and instructors in future CLEs. We've gotten some good feedback listed here. I won't read them all off for sake of time, but we've gotten some good feedback, and that operates on both sides of the spectrum in terms of very good positive feedback, and then where something is deficient, it alerts us to that. For instance, the not clear what materials should be reviewed, and that occurred in the course of our Valdez Jimenez CLE. So we were able to modify that moving forward. And then of course the suggestions for future CLE subjects has been very, very, very helpful. Obviously, as we move towards the end of the year, the substance abuse and ethics credits become more critical, and that's kind of where we're focusing now for these last 3 months. So that brings us to the 2021 Indigent Defense Conference. When we sat down to plan this, I think we were looking at 2 potential models. One is a 2-day conference in Las Vegas at the Boyd School of Law, with the goal of getting all 13 CLE credits done in that time. The second option that we were looking at was regional trainings in different parts of the state. With the regional trainings, we'd be looking at 1-day offerings, so it wouldn't encompass all of the CLE credits. It would be 1 day with some provided and the rest being made up through the monthly offerings. In order to get some feedback as to what preferences were, we sent out we'll call it a survey, but essentially an email soliciting feedback on July 29th. We sent it to 26 attorneys, and again, limited to that primary provider in rural counties, including defender office heads. So while they're closer to 44, 45 actual attorneys, only 26 emails went out because 2 of them included office heads to larger offices. We did get 13 responses back. Of the responses, 11 preferred the 2-day conference. We had 1 that preferred a regional conference, and then 1 we'll say the email was undecided and more informative than anything else with logistical issues. So it looks like of the responses, the 2-day conference in Vegas is the preference. So with that, what we're asking the board to do today, 2 things. One is we want to move forward with planning the conference at the Boyd School of Law in March of 2021. So we are requesting authority to expend the training budget to begin the planning process in that. The second part of, I guess, our ask or discussion today is just a discussion on the reimbursement policy. From the Interim Finance Committee, we received $19,836 for training. Estimating approximately 50 people, somewhere between 40 and 50 people. And again, that assumes that everyone from the bigger offices can go, but we know realistically that's most likely not possible. We just don't have enough money to pay the full boat for everyone. So the internal discussion is whether it should be, the payment method should be a scholarship that takes into consideration whether offices or attorneys have a training travel budget, or whether it should just be a pro rata distribution wherein all get a similar amount that doesn't cover everything. Chair Traum, I'm not really sure where you want to start, but the initial request is to expend the training budget to begin planning, and then some discussion on, get some feedback on what we feel is the most equitable distribution of that money.
She's on mute.
Sorry. Now I'm unmuted. Can you hear me?
Okay.
My apologies. I was trying to be good, and then yeah. So the $19,000 plus is your full budget for the year. Is that right? You're muted.
That is the full training budget allotted to attorney training. Yes, that's not our internal training budget for us, just for the year for attorney training.
Oh, okay. And you have all of that to spend on the annual conference. That's because you've been doing the other stuff for free?
Correct.
Okay.
And again, this money from the interim, that was the purpose of this request for the Interim Finance Committee request, was to get this money to put on a in-person conference. Obviously that happened, with COVID, and I think there's going to have to be some contingency planning, but that is still the intent and purpose.
Right. Okay. So obviously if it's COVID, we're doing it on Zoom and it's not going to cost $19,000. But I think that maybe the issue for discussion is whether we should be advising you on how to structure the scholarships, or we should just say, go ahead and do it in the way that you make sense to you. Maybe based on the follow-up contact you have with the lawyers in the community and what seems like a fair way to do it. But I just want to open that up for people to weigh in.
I think that this is Laura Fitzsimmons. I think they're in the best position to make those decisions within our budget.
Right. I agree with that. I mean, part of it is there might, I guess, be some expenses that are other than scholarships. And then it seems like you're having a fair amount of contact with the rural lawyers. So doing it in a way that just seems fair to that group to meet the needs and get people there is something that you can probably, just get the best information. I'm not sure. I think maybe if we could just approve the money, that's one way to say go for it.
Is there a reason why we have to limit this to the rural practitioners? And I'm asking it that way because out at the law school, there's lots of great big classrooms which we could fit more people in, and even with COVID still fit more people in. Potentially we could come up with a nominal fee that we could use out of our public defender and special public defender training budget down here, which would augment your 19,000, and we wouldn't have to pay travel expense because they'd just drive there instead of driving over to the courthouse or their office. And that might make your 19,000 go further if we add some people who will pay a small amount here to make a bigger chunk of money available for the cost at the law school.
So, make sure I'm not on mute. We did have that discussion internally. I think there were two reasons why we decided to target this the rural I guess community first. First is this will be our first conference that we put on. So working through the logistics with a smaller number seemed more manageable and give us some better experience to look at providing the larger conference with those ideas the next year. The second part of it was just the creating a kind of cohesive or creating connections within the rural community, giving something that is focused to them. Our CLEs of late have really engendered some really good discussion, and I think connections between issues that affect the rural communities more uniquely. And so with that in mind, we thought it better to approach that first, get the experience under our belt, and then when we have the opportunity for the second go around, we open it up to a larger forum.
Go ahead, Laura. Are you gonna?
Well, I'm just thinking about, I just volunteered to take a case out of a rural county on post-conviction pro bono. And in that case, the indigent defender reached out to Washoe County and to Clark County in email. So I've seen them, it was a very, very, very unique issue. And everybody's got their stuff, so there was little to no response. I agree with everything you said, but I almost wonder if in the context of the rural conference, we could just have something where at least, it's NACJ or whoever sponsors something so that the indigent defenders in Clark County, we can have, some kind of a gathering and people can start making those connections. I understand all of your reasons, but I just, really think that we need to start making those connections because I think that will inure to the benefit of the rural lawyers.
And to that particular comment, thank you. We have reached out to NACJ before the change of their leadership to, kind of see if there's any interest, and we certainly got some interest back on that. At this point, we haven't followed up with, what we're thinking is kind of a, maybe an NACJ, cocktail hour or something to that, something like that to see if we can get, those connections that you're talking about made. We haven't really approached them with anything more definitive other than whether or not there was some interest. So as we, get this planned, that is certainly something we're looking at doing.
I think that's a really nice idea, just to both have socializing, but also to have people networking, particularly like investigator to investigator, and kind of building up those resources so that you have more people to tap when you have an issue. Yeah, so I think that there's easy ways to kind of think that through so that you have real bonding and training, right, with the rural people, but then also a chance so that they're not isolated and feel connected to a broader solidarity community. Yeah. So any other comments? Am I right that people think we can just give a green light to the executive director and Jared to just carry on with this in the planning, and then maybe we'll get an update at one of our next board meetings about sort of what's planned?
I'm reading B2 in agenda item 9 as being an action item, but did we act on that? I could have missed it.
Well, it is an action item, but I think we could do it as an actual policy. Like we could propose that everyone get $400 or $200 towards the expense of the conference. But it seems, we could also do it more generally, which is you guys can figure this out, and let us know what you did or doing. But how are people, that would also make sense. So it's just say, you should disperse the money on to provide scholarships, and you should figure out how to do it fairly.
Okay, so if that's an action item, I'm making a motion. If it's not, then we've all agreed.
Ashish, your board counsel, just for the record, I just wanted to make clear for the board that the board may take action if they want to. They're not required to take action. If the board would like to defer this, with guidance to staff, that is possible. But the listing on the agenda permits the board to take action, but does not require the board to take action.
Right, but I'm just saying, why wouldn't we? Then we've gotten something off the table.
I second Laura's motion.
Okay. So the motion is just to approve the expenditure of the funds and have let the executive director and her staff figure out how to divvy up the scholarship money. So are we ready to vote on this?
This is Chris, just clarification, because I think you said that this could then become board policy. If that's the case, maybe we should asterisk in the minutes when we do board policy so it's easier for staff to pull it out separately.
I'm unclear on exactly what you mean by that. Maybe you could just say more.
Well, when there's policy, usually you have a policy book, at least for most governing documents. And sometimes it's hard to remember when it's a board policy versus just an action item versus whatever. If it's something that the board wants to put in effect as a policy, and I think that was the word initially used, all I'm saying is when whoever does the minutes asterisk it so that they can pull it out and go, oh, this is board policy, not just an action item.
Right, so let me just go back to the motion as proposed. Is that I don't think I heard you propose it as a policy. I think it was just a regular action item. So we're not proposing this as policy right now. Okay, so any other comments? I think, are we ready to just vote on that proposal by Laura, second by Jeff, to approve the funds and allow the executive director to disperse scholarships?
It was a motion, not a proposal. That's a joke.
Okay, all in favor, say aye.
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 Aye. Anyone opposed? Okay. So I expect at some point we'll just get another report on what's in store for the training, which is very exciting, and yeah, we'll be working together probably to get it planned. So that's great.
Thank you very much.
Okay, next on the agenda is our next meeting, which I believe we actually have a schedule of meetings. So we've already approved the meeting, which is slated for October 22nd at 1 p.m. So I don't think there's anything else for us to do about that. If there's anything that people in particular would like to put on that agenda for next time, you're welcome to suggest that now.
This is Chris. I'll be working the polls, so I'll be absent, but it shouldn't affect your quorum.
Okay, thank you.
And this is Laura, me too. I'll be working the polls too.
On October 22nd. Okay, so we should be mindful as that meeting approaches whether we will have a quorum. So I think, the sort of best way to look at that maybe is that respond to the meeting invite that you get. If we have an issue about having a quorum, we can figure out what to do. Okay. All right, so I think we're good on that. Let's move on to public comment. Is there anyone on the line who would like to make a comment, public comment limited to 3 minutes? Anyone? Not anyone muted? Okay, so no public comment right now. I think the next thing is do we have a motion to adjourn the meeting?
So move.
Do we have a second? Do we have a second? Did I miss the second?
Second, this is Lorinda.
Okay, thank you. Everyone in favor of adjourning the meeting? Say aye.
Aye.
Hi, thank you so much, Ann. Professor Trump, thank you. Thank you, everybody. Bye.
Thank you, everyone.
Take care.
Thank you.
Thank you.
For those remaining, thank you.
I wanted to get a number of people.
Hang up.
Just can't like, okay, you know.
Trying to get a number.
But you were great.
It says 129. It says 129 because people left, left, joined. Are you there, Colnet?
I'm still on, yeah. I just wanted to make sure everyone was hanging up.
Stop recording.
Stop the recording. Did you stop it?
I stopped it.